Consortium News. My name's Mary Kostakidis. Remarkable news this week with former US officials corroborating the CIA surveillance of Julian Assange and plots to kidnap or murder him activity first testified in the extradition trial by former employees of the security company guarding the Ecuadorian embassy. We also recently saw the main prosecution witness for the broadened scope of hacking allegation charge in the second superseding indictment completely discredit the beefed up charge by admitting that he lied to prosecutors. We'll look at what impact these new developments might have on the upcoming US appeal against Judge Barreza's decision not to extradite the Australian journalist, publisher and editor of WikiLeaks, the organisation termed by the former CIA director and Secretary of State Mike Pompeo as a hostile intelligence service. Now, just to refresh our memory, there are 5 grounds to the US appeal: that the judge made errors in law in her application of the test under Section 91 of the Extradition Act, that's the humanitarian provision, as to whether it would be oppressive to extradite Julian on the grounds of mental health, that the judge ought to have notified the US of her provisional view to enable them to offer assurances to the court, that as the defence's principal psychiatric witness misled the judge on a material issue, his knowledge of the identity of Julian's partner, that his evidence ought to be ruled inadmissible because he was not an impartial witness, or his testimony should be given more appropriate weight against the prosecution's 2 wholly independent medical experts, that she erred in her overall assessment of evidence regarding Julian's risk of suicide, and the US has indeed provided assurances responsive to the judge's specific findings, assurances that he would not be held under SAMS conditions or at ADX unless he does something else that warrants it in the meantime, and that the US would agree to transferring him to Australia to serve out his sentence. I'd like to welcome our 6 panellists tonight. Alexander Mercouris, an editor at the Duran and formerly a duty lawyer at the Royal Courts of Justice for 12 years. Alexander's a regular analyst on CN News. Bill Hogan from the Doctors for Assange Group. Bill's a physician and professor of health outcomes and biomedical informatics at the University of Florida. Lissa Johnson, a clinical psychologist who helped launch the Doctors for Assange Group in 2019 and has been writing about the psychological aspects of Julian's persecution for some years now. Julian Hill, a member of the Australian Parliament and Labor Party. He's also a member of the Bring Assange Home parliamentary group, which now has 29 members, including the leader of the Labor Party, leader of the opposition. Alison Broinowski, a former diplomat, academic, writer and author, who's acting chair of Australians for War Powers Reform, and Alison's been a long-time defender of WikiLeaks, and Julian's father, John Shipton. After we hear from our panellists, we'll be going to discussion, so please enter your questions in the chat function as they occur to you. Let's go to Alexander first. Alexander, please give us your assessment of how the appeal will go, and in particular, the indisputable parallels, or what appear to be indisputable parallels, with the Dan Ellsberg prosecution. Will the High Court accept this additional evidence of CIA malfeasance, and is it likely to lead to Julian being released?
Please unmute yourself, Alex. You're muted.
Can you hear me now?
Yes, that's better. Thank you.
Okay, my apologies. So, first of all, the High Court has enormous discretion whether they hear new evidence or not. And this is new evidence. I think they should certainly hear this new evidence, because the evidence that we are hearing about, all this information we're getting about what the CIA was up to, is first of all directly relevant to the whole question of his extradition, and it should have been disclosed by the US authorities at the trial before Buritsa. Now, to recap, the British government, Britain, does not extradite people to countries where they are at serious risk, whether life or health or whatever. That's well-established law. That's foundational law. What we now learn is that not only was the government that is now seeking Assange, Julian's extradition, very persistent in getting him and monitoring him all the time, but a powerful agency of that government, the Central Intelligence Agency, was conducting covert operations against him. They were doing so on the basis that it was his organization was an intelligence agency, and they were prepared to go to extraordinary lengths. They were prepared to kill him, kill other people too, and in fact kidnapped him, if they or do all of those sort of things. So this says to me that he should absolutely not be extradited to the United States. Moreover, though you should not, in theory, look at this new evidence like new evidence at an appeal, this evidence was not disclosed to the court by the US authorities, which it should have been. And therefore, for that reason, I think it can be and ought to be considered by the court at the forthcoming hearing. I will be very surprised indeed, very astonished indeed, if there is an application made to consider this evidence, and if that application is not granted. So we will see what happens. As I said, they have wide discretion in that field, but certainly I think it should be heard. And I get to say something else. If this extradition request were being made by the government of any other country, and this information had come out about what that country was doing in order to get the person whose extradition it was seeking, then I have no doubt at all that the British courts would refuse extradition after these revelations. It is because of the extraordinary position of the United States that there might be, that there are these uncertainties and these questions.
Thank you very much, Alexander. Are there any other comments you'd like to make in general about the upcoming appeal on any of the other grounds?
Yes, I mean this is a problematic. This is problematic because what the United States has been allowed to do is to call into question findings by the trial judge about Julian Assange's health, and this is really actually very extraordinary and extremely unusual. Generally, when a trial judge makes findings of fact, when the trial judge decides to accept evidence of an expert, an appeal court does not revisit that question. And of course, the first judge who in the High Court granted the United States permission to appeal on various grounds actually excluded that key question of the admissibility, or rather the weight of the evidence of the expert who is now being challenged. And I have to say, the fact that the appeal court then reversed its position, that it did a complete turnaround and said, well, we are going to let the US authorities reconsider this all after all. Well, that shows, to my mind, the extraordinary lengths to which the British authorities, including the British judiciary, are prepared to go to accommodate the US in this extradition case. I cannot imagine that that would have happened in any other extradition case on appeal other than one brought by the United States. And that's, I'm afraid, what creates the uncertainty about the whole proceedings. If they were prepared to do that with respect to the experts' evidence, well, one has to worry what else they're going to do with this new evidence that's just appeared. You know, they might say, for example, it's newspaper gossip. We're not going to consider it for that reason, even though it's clearly very well-founded newspaper gossip. And my guess is that it's been leaked by people within the US government precisely because some of them are very unhappy about the way in which this extradition has been conducted and about this campaign against Julian Assange. And that's, I think, an important fact, but that's a separate issue. So it makes one very uneasy that we are looking at an appeal on these grounds, reversing a decision of the first judge. And it makes one uneasy about how they're going to handle everything. But of course, now with this new evidence, it's becoming more difficult for them, I would have thought, to just disregard all of this, close their eyes, say, we don't see all of this evil, if you like. We're just going to go ahead and extradite him, despite all the clear risks to him, risks obviously to his health, assurances from the US authorities which can't be relied on, and of course assurances from a government which is now known one of its key agencies was actually prepared to take extreme steps of kidnapping and, if necessary, murder. So that's where we are now, I think, in this case.
That certainly seems to be the main issue at present. Let's have a look, though, at the medical grounds more closely. Bill Hogan, what are your thoughts about the medical grounds of the appeal?
It seems to be, to me, I'm not a lawyer, but the United States is going after the main defense medical expert witness as the primary focus and sort of a Hail Mary pass, as we say in American football, because that is the evidence that on the basis of which the judge denied the extradition. The judge denied the extradition on the fact that to do so would be oppressive by means of mental illness and disorders, specifically depression. So the key witness, Dr. Michael Koppelman, made a finding that Assange is at a significant risk of suicide and that it would not be a rational decision. It would be almost compulsive in nature, out of his own control. And so without that, the judge's basis for denying extradition is gone. And so if the prosecution can get this defense expert witness testimony thrown out, the whole denial of extradition crumbles significantly. So Koppelman, in his initial filing, long before his final report and the hearing of medical evidence occurred, withheld his knowledge of Stella Morris's identity in his filing before the court. And the prosecution is using that to say that this witness misled the court and therefore failed in his duty, and he's partial to the defendant and not an objective witness, and therefore he should be thrown out. However, first I want to address one thing that happened at the High Court, and then I want to address the new revelations by Yahoo News. So one thing at the High Court that the prosecution lawyer Claire Dobbins said was that Judge Baritzer should have interrogated why Koppelman was willing to mislead, unquote. Well, she in fact did that already. So we know from Judge Baritzer's ruling that there was an additional statement by Dr. Koppelman submitted in November 2020 after the extradition hearing occurred, as well as an additional statement from Gareth Pierce, who's another one of Mr. Assange's lawyers, dated December 1st. And there was therefore detailed further submissions from counsel in writing about this issue. So the judge already did that. So Dobbins lying to say that Baritzer did not, in fact, interrogate why Koppelman did it. And so why Koppelman withheld the identity of Stella is because there was serious concerns for her safety and the safety of the children. And these Yahoo News revelations draw that fear into stark relief and provide, if there wasn't ample justification before with the news about UC Global and assassination attempts, the Yahoo News revelations clarify and amplify just how significant a risk it was. So the United States unleashed its full force of its counterintelligence against a small journalistic organization that does not have the basis to handle that like a nation state intelligence service would. And of course, it wasn't just Assange they wanted to assassinate everybody in WikiLeaks. And it wasn't just Assange they wanted to classify as an information broker, but they're going after multiple journalists, including Glenn Greenwald and Laura Poitras. The other thing is that, with this intense pressure from the world's most devastating and dangerous intelligence service in the world, it certainly explains why that would lead to Assange's symptoms of severe depression, and explains even further the torture that we know exists against Assange. It's important to note that Koppelman intended to make full disclosure all along. With the advent of the pandemic, the proceedings got delayed. So there was 9 months in between his preliminary filing and his, about 7 months, I would say. But January, he made his preliminary filing, and then in August, his full report. The medical evidence was supposed to be heard in, I believe, March, and then it got postponed to May, and then it got postponed to September because of various issues due to the pandemic. So during that long delay, and due to the pandemic, there was a bail application, and it was at the bail application because for a bail application, you need to say where the prisoner will go, and he was going to live with Stella, and so they had to make Stella's identity known. So Koppelman was caught up in this weird confluence of circumstances that he had a delay in between when he initially filed and when he came clean. And so there was no misleading of the court. The judge said she was never misled. There was always a full intent to reveal the witness, or to reveal Stella, and be completely honest about that. And Koppelman's evidence is unimpeachable otherwise.
There is, though, the article that was raised to also discredit Koppelman. Yes.
So there was an article published in 2017 in the British Journal of Psychiatric Bulletin that is a 2-pager that's an interview with Koppelman about his intent to spend his retirement getting justice for people who have been wronged. And he, in particular, took the testimony and interviewed, did medical assessments of Guantanamo prisoners. These are British citizens who were held at Guantanamo and returned to Britain at the urging of the British government because of the revelations of torture. And the British government, rather than try this case, and probably at the urging of the United States government, who didn't want their malfeasance exposed at trial, settled the case. So there was a settlement of something like £30 million to the British detainees at Guantanamo. And Koppelman was instrumental in that. And so the interview is largely on that basis about him. But in that article, he speaks of Gareth Pierce being exceptional at playing within the system. And then he kind of repeats that, but leaves out within and says, plays the system. And so the prosecution says, oh, he's biased because he wants to play the system against itself. And so The other thing about this is if you, this article is not properly introduced as evidence, even at appeal. It's absolutely absurd that they couldn't have found this for the original hearing. Like, how did they only now finally suddenly find this article, which, by the way, is in the public domain. I didn't have to use any of my university library access to access this article. So it's completely silly that they couldn't have found this. You know, it's almost embarrassing, I would think, for an attorney not to have been able to have found this and introduced it at the original hearing. So but what it illustrates is the desperation and the absolute, they're throwing absolutely everything at Koppelman that they possibly can, and an absolute desperate attempt to attack this eminent expert who the judge and the prosecution had a full opportunity to hear and cross-examine. And the cross-examination he withstood magnificently, actually.
Thank you for that. I'd like to go to Lissa Johnson now. Lissa, tell us from your perspective what you make of the medical grounds of this appeal.
Yeah, well, Bill's absolutely right that it's a desperate attempt to discredit Koppelman. And I feel like, you know, yet again, we're at a juncture where the US is really scraping the bottom of the barrel to try and, you know, prop up their non-existent case, prop up their groundless appeal. You know, as Bill said, they're attacking Koppelman on the grounds that he sought to protect Stella and Julian's children from harm. And at the most recent hearing where the grounds for appeal were broadened, that was characterised as being a lapse, as being biased. There are things called criminal procedure rules that, you know, again, not a lawyer, but I understand that was what was said to be violated. And under those rules, expert witnesses need to be impartial and objective. So there's an argument that protecting Stella showed that he was impartial, not objective, should be thrown out. And they said that Judge Baretza sort of downplayed that too much. She said it was an understandable human response. So they're saying, well, you know, that's not good enough. But all of that is really a mischaracterization of what went on. So, you know, it wasn't a lapse. It wasn't biased. And even to call it an understandable human response, it was more than that. So in terms of being biased, you know, Koppelman submitted 2 reports. One was at the end of 2019, that was where he protected the identity of Stella and children. Then another one the following year, just before the September hearings, then, you know, their identities were already known. During his first report, you know, to conceal the identities of Stella and the children worked against Julian's interest. It worked against the defence case, and it even worked against Koppelman's own arguments, because he was arguing extradition to the US. It poses a very high risk of suicide, and he said, to the extent that I'm as certain as any psychiatrist can be that Julian Assange would suicide. And that's a very strong statement. You don't often hear psychiatrists and psychologists say something that, you know, with that much certainty around suicide. And Koppelman has decades of experience. He's very senior. He's, you know, former chair of about 5 psychological bodies, on the editorial boards of a bunch of peer-reviewed journals. He's, you know, right up there. So why would he, you know, and the fact that Julian has young children and he's in an ongoing relationship with their partner and he speaks to them as often as he can in Belmarsh, and that's one of the things. It's a protective factor, and that later came out as a key protective factor. And one of the reasons that extradition would be such a risk is that Julian would be separated from his children and his family. So why would Koppelman suppress that when it was in Julian's interests? And the fact that he did really is the opposite of bias. It's the height of objectivity. And, you know, that was more than a human response. He was required to do that by his codes of ethics and professional practice. You know, so psychologists and psychiatrists have code of ethics that they need to abide by. So he was both an expert witness and he's also a psychologist and a psychiatrist. So he had codes of ethics that he's bound by in each of those areas. And as a psychologist and psychiatrist, you know, we're all required to prevent harm and avoid acting in a way that can cause harm. And being an expert witness doesn't change that. And where children are at risk, psychologists and psychiatrists are required to, the child welfare is paramount always. So I'll just read the relevant sections of the ethical codes that Kopelman was bound by. So the Royal College of Psychiatrists, with respect to responsibilities of psychiatrists who provide expert opinion to courts, says there's a duty, obviously, to form an opinion fairly and honestly about matters relevant to the court. However, psychiatrists must still pay attention to their medical ethical duties. They need to have regard to the person's welfare and to the prevention of harm, albeit they are seeing the individual in a legal context. So those ethical duties that refers to, so that's for expert witnesses. The ethical duties of a psychologist and a psychiatrist under their codes of ethics are that they're required to prevent serious harm occurring to another person. They need to ensure the avoidance of harm, in which, quote, the child's needs are paramount. Psychologists and psychiatrists should contribute to whatever actions are needed to safeguard children. The needs or interests of adults should not be allowed to take precedence ahead of the needs of the child. So that's what Kopelman was bound by. That's what he abided by. And yes, no doubt there was an understandable human response, but he was also upholding his ethical responsibilities, both as an expert witness and as a psychologist and a psychiatrist. And as Bill talked about, he knew at the time what the world knows now, that Julian and his family were under threat, threats of kidnapping and poisoning, and, any psychologist or psychiatrist worth their salt knows that an entity, and that's essentially the prosecution. The prosecution is the US national security state. That's the same entity that was talking about kidnapping and poisoning this children's father. And Stella said after the most recent hearing on the appeal that they've been enduring unpublicised threats and intimidation for years. So these are things the public doesn't know about. But now, thanks to Yahoo, a lot of, even CNN reported on the kidnapping threats and so on. Kopelman knew that. So any psychiatrist knows that any entity that's, plotting to murder and kidnap a defendant is capable of anything. So he had to protect those children. He had no choice. It wasn't biased. It was ethical conduct. So, I feel that at this point, the British judiciary is at a really critical juncture in terms of the credibility and integrity of the British legal system, because on the one hand, they can stand with the prosecution that's been plotting to kidnap and poison the defendant, who's the key witness, is a convicted fraudster with a history of child sex abuse. They can stand there and seek to discredit a psychiatrist who is upholding his code of ethics and his, responsibilities to protect child welfare. Or they can uphold an expert witness's right and obligation to act ethically. And I guess at this juncture, it's no surprise that prosecution would be hostile to ethical conduct, but hopefully that's not the case for the British judiciary. So, that's an important thing, I think, to be aware of in terms of Kopelman's testimony. And it's a bit rich also that the prosecution is seeking to discredit Kopelman when Kopelman was the only expert witness to assess Julian during the time when he was suffering from severe mental health difficulties when he was in the healthcare wing. The others saw him after he'd been moved into general population, and he was feeling better as a result. Kopelman saw him 17 times. Defence witnesses saw him a couple of times for a handful of hours. Baretsa was very sort of glowing in her description of Kopelman's testimony because it was exemplary. It was over, around a year. He reviewed the prison records extremely thoroughly, which the prosecution witness Blackwood didn't. Got a lot of that wrong. Blackwood, Kopelman took great pains to research, background material, history, previous visits with psychologists and so on. Blackwood got into court, and just like the first judge at the bail hearing, called Julian a narcissist. So the prosecution calling Kopelman biased is really the pot calling the kettle black, which has been something that the prosecution's done all the way through this. I could go on and on. I'm aware of time, but I think I've said the most important things about Kopelman. One more thing to be said about the most recent hearing. The psychological evidence was also mischaracterised by the prosecution. The prosecution said that the prosecution expert witnesses disagreed that Julian showed traits of being on the autism spectrum, and that's not true. They both said that he showed autism traits. There was only one witness who had the expertise to diagnose autism spectrum disorder. That was Dealey, and he performed a structured interview, as you should. He has a long background working with autism. He heads up the National Autism Unit. He's published papers on diagnosing autism, including in high-functioning people, which is a very specialised, very very difficult area. You require a lot of experience and expertise to be able to do that. Dealey was the only one with that expertise. He's the one that made the diagnosis. But the prosecution witnesses did say that Julian showed traits of autism.
Fuck's sake.
Which is the material issue as far as suicide risk is concerned. So whether he shows those traits. So essentially elaborating on what Bill said, that this is really a desperate attempt at scraping the bottom of the barrel to attack rock solid medical evidence.
Thank you, Lissa. This seems to be clearly a political case to many people, other than a lot of our politicians in Australia, but not Julian Hill. So, Julian, if I could come to you, the mantra from our foreign minister is that we can't intervene in another country's legal process. Why is that not a tenable position in your view? And what will Labor do about Julian Assange if they're in office next year?
Thanks, Mary. I think the legal issues have been well covered, and I'm not going to delve into them. But I agree with you. I think it's an inherently political case, and that goes to the core of this issue. I think that the US should have, frankly, banked their win in the first outcome, in that they established, to my chagrin, but they established every point of principle they were seeking, except they didn't get their man. They could have banked that point of principle and the precedent that they've set. It's a terrible precedent. In substance, the argues of principle, but accepted the humanitarian grounds and just let it go. It's gone on for long enough. But it's an inherently political case. I suspect, sadly, that this issue may never be resolved ultimately through the legal system and the courts. If the US lost this, they may well try something else at some other time. It's an inherently political case, and that's my core point. If you leave with nothing else, and everyone says politics in a pub, so people can go and get a beer whenever they want, but if you leave with nothing else, that is my core point. This is a political case, and political crime should never form the basis of extradition. I'm not a lawyer, practicing lawyer. That's a terrible law student. I sort of got there in the end, but that was enough of that. But I don't know, Alex may have a view whether that's a formal principle, but it's an understood principle from my perspective that political crime shouldn't be the basis of extradition. This case is designed to mute whistleblowers and investigative journalists and have a chilling effect on the reporting. And as I said, even the last case outcome sets a dangerous precedent worldwide that anyone, anywhere, anytime can be charged by the US government if they publish something that embarrasses them, in effect. Now, people shouldn't be prosecuted for their political beliefs or journalistic activities. And so therefore I say that this case needs a political resolution between governments. In answer to your direct question at the start, Maurice Payne, Scott Morrison hiding behind trite little throwaway phrases, they're not engaging in the substance of the arguments. They never have at any point. They say, Morrison said, he should face the music. What does that mean? He's never been convicted of any crime. There's no credible evidence put up. Maurice Payne, we can't intervene in the legal system of any country. Well, they do that all the time. Really, I help. The department provides consular assistance at a minimal level, but we make critiques of the legal system of many countries. I've got citizens, I was just on a Zoom about issues in Cambodia. We make criticisms of all sorts of flawed legal systems on behalf of our citizens or in support of our beliefs. So I'll leave it to others to make those criticisms. But I think that point, the political observation is our government currently is just batting this stuff away because they don't want to engage in the points of principle. We can talk about them at some point. Your final question there was, what's Labor's position? Well, Anthony Albanese is the opposition leader and alternative prime minister of the country, has made his statement. I asked him a question in caucus, I think, and he made a clear statement. This has gone on for long enough and thinks that the matter should be brought to a close. Now, there's many ways that can be achieved. I know we've had a bit of criticism from some of our left comrades out in civil society that, you're using weasel words. I can't make specific commitments. I don't know. If we form government, we've got a very clear position that was adopted unanimously at our national conference that this should end. The circumstances in which that ends depends on the time and what's happened in between now and whether there's a court case afoot and so on. But I'm confident that a Labor government will convey our position to the US government, hopefully the Biden administration with Albo as Prime Minister. So, that's a clear position from our point of view. I moved that resolution at national conference. It was unanimously passed. It sets the context for Labor governments to operate within.
Thank you, Julian. There seems to be a very simple question that needs to be asked right now by our government, and that is that twice now we've heard reports that the CIA surveilled and plotted to kidnap or murder an Australian citizen. There's been absolutely no comment from anyone in government about that. They should at the very least, shouldn't they, be asking the US, please explain what's this about? Is there any truth to this?
Well, at the very least, Mary, you're spot on. This is not a spy movie. We're not in a spy movie. This is not the James Bond premiere. This is real life. This is a credible allegation, not by some fringe nutty conspiracy theory website. This is a credible allegation that has, sources behind it, that the intelligence agency of our biggest ally and security partner was seriously contemplating drawing up plans to murder one of our own citizens in an extraterritorial killing. I mean, it sounds kind of mad when you say it, but in the country where our head of state lives, the foreign queen, that's a whole other panel. I won't go off on that tangent, but I mean, this is ridiculous. You can't just ignore it and pretend it didn't happen. It requires a formal discussion with the US government. And I'd be very happy to hear that these are not true. These reports are not true, or that this was a rogue, silly conversation in the previous administration. We apologise. Whatever it was, you can't just pretend it didn't happen. I think that the government can and should say and do something. It's actually not that hard to get an appointment with the US Embassy if you're a politician. As one of the, it's not always that easy either, but it's not impossible, particularly for the government, really. I organised a delegation for George Christensen, Andrew Wilkie and myself. We went down, we had a fair hearing with the Charge d'Affaires. We went in, we had a robust discussion. I think there was a degree of surprise that we were actually quite civil about it. We're not crazy. We've got a view. It's a principled view. We explained our view. We discussed the view. That was relayed back to Washington. If I can do it as an opposition backbencher, I'm quite sure that the foreign minister can get in there to convey the view and ask that important question. It's not acceptable. Can't just pretend it didn't happen.
Thanks, Julian. Alison, you've been a long time observer of this case, and with the benefit of your experience as a diplomat, what's your view on where we're at right now? Alison,
thanks.
You could
thanks, Mary.
unmute.
Thanks, Mary. I second what Julian has just said completely. It is a political matter. It is not a legal matter. Julian is in jail accused of no crime. I mean, legality is not the point. What is going to resolve this thing is some political intervention, which Australia has done many times in the past on behalf of people who were actually accused of awful crimes like drug trafficking and child molestation and all sorts of things. Julian is accused of nothing and guilty of nothing. And there he is in Belmarsh, and successive Australian governments and prime ministers have turned a blind eye to this. The solution has to be political, just as it was, for instance, when John Howard was facing an electoral defeat, and he finally went into bat for David
Hicks.
Thank you, for David Hicks and others, indeed. Now, what do we have here? What is different here? The fact is, as others have said, it's the US that is accusing Julian, our great and powerful ally. Now, you would think that given what we've now just given up with AUKUS, we have surrendered our sovereignty forever, according to Scott Morrison, forever, plus made ourselves a nuclear target, plus done all the things that the United States wants us to do. You would think that a prime minister could walk in and remind Joe Biden, who his name is, and say, we've got this man who's locked up, and you guys are trotting out all sorts of stuff against him. Furthermore, the CIA has done everything that we've just been discussing and plan to do more against him and his family. This is enough. We have given you a lot. We now want something back. Thanks. Is this beyond Scott Morrison to do? I mean, I know he takes responsibility for nothing, but you would think that given that his chances of winning the next election and the grounds on which he's going to win it are shrinking by the day, he might at last do what Howard did and be induced to go and do this. Now, the letters that we've all sent and your group has sent and everyone who's supported Julian has sent time and time again are ignored for as long as the politics lasts. And that's what we're here for in Politics in the Pub. Because what happened with David Hicks was that there was a very smart American lawyer representing him who made a terrific impact here. People rose up and said, this is enough. Now, I'm asking, how can we get the Australian public to that position? I mean, Julian's friendship group is a very good start, but we need the pressure of people, the public behind it. And we don't get it from the mainstream media. And this is the difference between now and David Hicks's case, because the mainstream media picked it up. They realized that Howard was vulnerable. They saw this as an issue and they talked it up. Now, it's not being talked up because you and I know people who say, oh, Julian, it's a bit dubious, isn't it? And you start Julian 101 with people. As Caitlin Johnson has done time after time on her blog and spelled it all out, 15 or 20 of the allegations against Julian, all of which she quite rationally dispenses with. This is the kind of political groundswell that we need. Now, thanks to Politics in the Pub for helping us maybe get along with it. But the main question for Morrison is, if he won't do it, why won't he? For an Australian citizen accused of nothing, guilty of nothing, and all it requires is his intervention to do it. He could even profit from it politically if he had the guts. I have only a couple of other tiny things to mention that others haven't. One is, I don't know what's happened to the Spanish court case about the investigation of their security firm, who was, of course, supplying their stuff to the CIA, as we all know. That court case, I understand, was going on in Spain. I haven't heard the results of that. Maybe others know. Secondly, and this is probably for Lissa more than anybody else, if you are in jail and there are large numbers of COVID cases in your jail, let me just say that in Australia, the rates of infection with COVID-19 are 10 times, in Australia, 10 times that of the outside population. Imagine what it is in London, where their infection rate is so much higher than ours. How can, and this then becomes legal, doesn't it? How can the British justice system expose Julian to that kind of risk when he is in their custody and could die? We know what they want, don't we? But how can the justice system tolerate this? That's my other question. Thank you.
Thank you, Alison. Before we go, you've raised a number of interesting questions that we do need to address. Before we go to you, John, I wonder if, Alexander, you might comment, if you can, on what the latest is on the CIA, the Spanish case, if you know. Could you unmute your microphone, Alexander?
Yes, sorry.
Thank you.
I don't very much know about the state of the Spanish case, but I'm going to make a confident assumption that it is ongoing and is working its way through the Spanish legal system, because I am sure that if there'd been a decision, we would all know about it. I mean, I find it very difficult to imagine that it would just pass by the radar unnoticed, if I may say. Can I make a few very quick observations about some of the things people have said? Indisputably, this is a political case. This is not disputed. In fact, the tradition in Britain is that we never extradite people in political cases. But in this case, the judge decided that there should be an exception, because though the extradition treaty between the United States and Britain says that we do not extradite people to the United States on political charges, the Extradition Act, which brought that treaty into law in Britain, omitted that phrase, something which is apparently consciously done by the Blair government in order to make it possible to extradite people who were involved in terrorist acts. So this is, again, another violation of our political and our legal traditions. This is a profoundly political case. The US at one point tried to get away from that, which is what all those hacking allegations were all about. And as has been absolutely rightly said, those hacking allegations have essentially collapsed with the evidence of the witness, the key witness who was making them, now absolutely discredited. And the second point about Professor Kopelman is, of course, there's no question at all about his professional competencies. Nobody is saying that he's not a person fit and capable of reaching a view about the kind of issues that he gave evidence about. The only issue that has brought his evidence into any question is something that the judge herself was fully aware of, that he took steps that he felt were appropriate and which Lissa says he was ethically bound to do in order to safeguard children. So this is just a few quick points that I wanted to make. I agree with every point that people make.
Thank you, Alex. Just one thing, just on the last point you made, it would be, of course, disastrous if Kopelman's evidence was regarded as inadmissible by the High Court. What would take precedence, the Criminal Procedures Code or the Professional Ethics Code?
I would have thought the Professional Ethics Code, actually, in this. I mean, I cannot imagine that the court would ask a professional person to act contrary to their ethical code in order to give evidence to the court. But the point is, my opinion anyway, is moot, because the court was not deceived. The judge knew exactly what had happened. She heard his evidence. She heard him under cross-examination. She was able to weigh his evidence against that of other witnesses. She was familiar with the objections that the US authorities were making. And she said, well, in spite of all of that, I found him a convincing and credible witness. His evidence appears to be corroborated by other facts, so therefore I will go along with it. And that's something every judge is entitled to do. And I'm just staggered. I'm really concerned about the fact that it's now being put in question in this appeal process. It's one of the things about this appeal, it's the single thing about this appeal process which makes me most uneasy, and which makes me uneasy about how they're intending to approach this whole thing. I do hope that the judges understand ultimately what their responsibilities are. That's about as much as I think I'm going to say about that.
Thank you, Alexander. John, we'll come to you. You, of course, along with Stella, are closest to Julian, to his lawyers, to his supporters. So we're very keen to hear from you today.
Thank you, Mary. Well, just a couple of things to say. One is that it's the manipulations of the Crown Prosecuting Service and the Department of Justice that ensured that the entirety of the focus now is on Julian's character and his psychology, and they've also brought in Stella into the examination in the court. This is compared to the Himalaya of crime and the benefits brought to the public in the United Kingdom and in the West by the exposure of those crimes on WikiLeaks. Those benefits are clear. Afghanistan is now, they've withdrawn. Iraq war is over. Guantanamo Bay is on the cusp of being closed. The revelations brought by WikiLeaks and Chelsea Manning have worked their way through the body politic, and as a consequence, the people have removed support from governments in pursuing those wars. The scandals, of course, will continue to manifest themselves over the coming years, but the public even have invented amongst themselves a meme, endless wars. All over the United States, it's said all the time. The support for the wars has been removed. The benefits of those leaks are tremendous, a gift to people right through Australia, United Kingdom, and Afghanistan, Iraq, the Middle East, and the United States. The focus being changed to Julian's psychology in itself is a scandal. What is to do with this Julian coming to the end? Actually, what it has to do with the extradition is naught, nothing whatsoever. Also, I'd make the point that Professor Koppelman had 17 visits over a period of 3 months, plus spoke to me a couple of times. We met and then spoke on the phone a couple of times, other members of the family. Time, that is, if there's to be a reevaluation of Julian's psychology by a psychiatrist, there's another year involved before a hearing can be put together about that. That in itself is another scandal. Next, Melzer, Professor Neil Melzer, Professor of Law at International Law at Glasgow University and the Rapporteur on Torture and Unusual Punishment, has put together a report, an exacting report on the procedural irregularities extending from Sweden, brought itself into disgrace in this matter, into the United Kingdom, brought the Crown Prosecuting Service and its administration of justice into disgrace, brought the Australian government and its ethereal standing above the circumstances of the prosecution and persecution of an Australian citizen, brought themselves into disgrace in every world forum. The standing of Australia as a multinational relationships between nations emerges from the unipower, the standing to enable us to negotiate with other powers and other states is brought to ruin because we just obey. We just obey, so we're not significant. Next, the United Nations Working Group on Arbitrary Detention, 17 professors of law examining Julian's circumstance and declaring that Julian was arbitrarily, this is 2017, arbitrarily detained and ought to be released and compensation paid. Another report came out in February 2018 asserting strongly the previous report of the working group. That report derided in the United Kingdom, ignored in Australia. In the hearing in January, in the hearing in September, Professor Melzer was just called Nils Melzer and political diatribe, when in fact every single point in the report is the abrogation of non-derogable human rights and procedural irregularities committed by the Crown Prosecuting Service and the Swedish Prosecuting Authority in a documented conspiracy. This report is in the hands of the Australian government. I know this because our Kelly Tranter's FOIs have the report before us. 4 pages on either side of the report are completely redacted. So a scandal which embraces Australia and its relationship with the United Kingdom and the United States, a scandal which embraces disgrace brought upon the Swedish Prosecuting Authority, a scandal which brings disgrace to the Crown Prosecuting Service, a scandal which brings disgrace to the Department of Justice, and a further, if they need any more scandals, to the CIA and its involvement with German ambassador, United States German ambassador Richard Grenell, and I can't bring his name to mind. He's died recently, but as if they need any more.
Sheldon Adelson?
Sheldon Adelson, yes, an unpleasant man, unfortunately. But so it goes that the way out of this is clear to everybody, that the Australian government use the facilities of negotiation and the imagination of skilled diplomats to work a method of face saving, if you can, I mean, it's how to go about a face saving for the Crown Prosecuting Service and the Swedish Prosecuting Authority and the Department of Justice will be a real test of Australian diplomats. However, the possibility is there. I just finish off my rather worked up and vigorous comments and say that we'll be over there for the hearing on the 27th and 28th. The support in Australia is magnificent. Everywhere I go, I get a good reception. The parliamentarians are generous with their time and with their advisors and staff. The people themselves are welcoming. And these tours that I undergo go right up and down the east coast of Australia. Furthermore, that was the same in 17 cities in the United States, in the same in Germany in 5 cities, and the same in France, in Paris and Lyon, the same in Madrid, the same in Oslo in Norway, the same in, surprisingly, Stockholm. Similarly, in the United Kingdom, the reception and the strength of the support of Julian is very strong. Every single politician, parliamentarian, and diplomat in the world would benefit vote-wise by supporting Julian. You might lose 2 votes, you'll get 10. It's the odds to nothing. I cannot understand why the Australian government and other governments don't put their shoulder behind this and solve it, because it brings benefits. It's already brought huge benefits to populations throughout the world, and it will bring benefits to the administration, to governmental administration, by showing that governments can support and can act in cases where clear injustices are seen. Thank you.
Thank you, John. Thank you. I'd like to ask you a question about the appeal, one of the grounds of the appeal, and that is the assurances. What's your response to the assurances that the United States has offered that Julian won't be held in the conditions that his doctors fear he will and lawyers fear he will, and that he won't be going to ADX, and he'll be able to come back to Australia to see out a sentence?
Well, they're complete rubbish. You know, it's now 12 years moving towards 13 years. They just want to murder him. That's all. They want him dead. They discuss means of doing it. They've found a legal means of doing it. It's 12 years. It's no joke. They've been pursuing Julian Assange in the embassy. In fact, they conspired to keep Julian in the embassy. That's the Crown Prosecuting Service and the Swedish Prosecuting Authority. The Crown Prosecuting Service, Paul Close, told the Swedish Prosecuting Authority to bugger off. It's just documented. We have the evidence there. You shake it under Maurice Payne's nose. My God.
There was also evidence given at the extradition trial that the United States has offered such assurances to the United Kingdom in the past and reneged upon them.
Well, you know, the European Court, see, the thing is you can't refuse the assurances between states. It must be clear to us. They can't say, no, your assurances aren't worth 2 bob. They have to find something else. The European Court of Human Rights, in a hearing, was given assurances by the United States in a particular case of extradition. The assurances naturally have to be accepted. They were accepted. The person was extradited to the United States and put in SAMs, special administrative measures. You know, the assurances are worthless, but between states, they must be accepted. I understand that. So other means have to be found by the diplomats, by the lawyers, and by the administrators, and then enforced by the politicians.
Thank you, John. I'll just take 1 or 2 questions I think we've got more time for. But before I do that, there's a request here for Julian Hill. There's some interest in the declaration by the Australian Labor Party of support for Julian at the conference, and we're being asked for the link. So could you put it up on your social media, you know, whether it's Twitter and Facebook, etc., and perhaps also give it to Consortium News, pass it on to the producers here, so that you know, we can make that available to whoever's interested.
Sure, I'll pass it on to Kathy in Consortium News. That's probably the easiest spot. It was a resolution at the conference, so it's probably best if I just send it and they can create the link. It's our website's not fantastic. That's probably the best way of putting it. So there'll be a great big boring book of the whole platform, and the resolutions form part of that, but I don't think there's a separate link, so I won't burden you with hundreds of pages. Okay. I'll send it to Kathy.
Great, thank you. And a question for Alexander, if he's still there. There, Alex? Yep.
Yes,
okay.
I was.
It has to do with the this new evidence. which isn't actually evidence yet. They're reports. So how is it turned into evidence? I'm assuming Julian's lawyers are now trying to establish contact with these individuals to see whether they're prepared to testify or to provide witness statements, and to request that their identities remain anonymous, as the two former security guard employees did in the Spanish case. That would be the only way the court could consider that evidence, I assume.
I think, there's going to be real problems creating this into evidence, in the sense that all we have at the moment is newspaper gossip. But not newspaper gossip, but media reporting. But the Americans are going to say this is gossip. Now, the point to say is you can do this in various ways. One of them is to do what Julian was saying earlier on the program, is you can go directly to the US authorities and you can say, is this evidence true? And, if it is true, why was it not disclosed previously at the court hearing before Berica? And that's the obvious first step to take. Now, of course, the US authorities may decline to answer. They're not, notice, up to now denying this evidence. But other than that, if you can't get it from the United States, you can also go to the British authorities, because the British authorities were also to some extent implicated in some of these activities. And you can ask them too, and you can get your politicians to ask those questions. People, like MPs. We have MPs in Britain who also support Julian, and who would undoubtedly be willing to make those sort of requests. And again, I think this is an entirely appropriate question at this time in legal proceedings, and that's an obvious first step. If you can't get past that point, well, I'm afraid you have to get in touch with Yahoo News, try and establish contact, as you said, with the people who are involved. And if you can't do that either, you can still, it seems to me, come along to the court and say to the court, well, look, we're getting all these extremely concerning reports. They're very concerning indeed. They are consistent with the fact that this is a political case, which is what we discussed previously. It is consistent with the fact that Mr. Assange was placed under all this sort of surveillance. Given that this is so, given that these reports are appearing, we cannot press ahead and extradite Julian Assange until this issue has been fully clarified and we understand exactly what happened. Because if we do, then of course there are all kinds of risks which these reports appear to give credence to. So you can point that out to the High Court, and you can ask the High Court to itself make orders. They can actually give, the court can give orders for information to be provided, and all kinds of things can be done. And I'm sure they are being done.
Just one final question, Alexander, for you from me. What happens if, take the worst case scenario, that the US win this appeal? What's the next step?
I understand that there is an appeal to the Supreme Court of the United Kingdom, and that's going to be an enormously fraught appeal, because obviously it's not usual for the Supreme Court to intervene in cases, but it can do where there's an important issue of law or public policy. I would say obviously there is in this case, and we will see what happens. But there would be one last route of appeal. If that didn't work, you could still go back to the government and ask them to reconsider, because of course they have to agree. But there would still be a further appeal to the Supreme Court of the United Kingdom.
So if the defence want to cross appeal, they don't do that to the High Court, they go to the Supreme Court.
No, a cross appeal would be to appeal against those parts of Berica's judgment with which they disagree. Now, that's been talked about a lot. It's uncertain to me whether it's actually going to happen. They would need permission to do it, I think. But they could argue that in the appeal that's going to happen before the High Court at the end of this month. If they lose at that hearing, then they can cross appeal. They can appeal further to the United Kingdom Supreme Court.
Mm-hmm.
And as I said, that would be an enormously involved legal battle with some of the most powerful legal minds in Britain coming to look at this. But it's not easy to get the Supreme Court to involve itself in cases of this kind.
Thank you. John, one final question to you. This clearly can, go on for decades longer, and it is a political case. What can the public do to put pressure on our politicians to take action?
Well, what we do, and we've found very, very effective, is in an electorate, take up a petition among your friends who are in the electorate and present it to the parliamentarians that represent your electorate. This is very effective because it gives the parliamentarian an understanding that there's a series of votes there that he can get by making simple support statements for Julian Assange. As to the governance of Australia, demonstrating support for a person, an Australian citizen, who is who has the burden of injustice placed upon them, it gives cohesion in the body politic and consequently support to government policy. It makes it easier to govern. So there's every advantage in just doing the simplest thing, is taking up a petition within your electorate, even if it's only 5 people or 6 people, of those people who are part of the electorate, and give it to the local parliamentarian. He will benefit immensely, you will benefit immensely, and the structure is so beautiful, is that the parliamentarian takes the concerns into the sovereign majesty of Parliament and asks the executive to act in the interests of the sovereign majesty of Parliament. So it revitalises Parliament. Every step of the way, it brings great benefits to the people, the parliamentarians, and of course to Julian.
Thank you, John. I think we also need some questions put to the Prime Minister in Parliament about this. I'd like to say thank you to all our panel for being part of this, and John, everybody's thoughts and many efforts, I hope, will be with Julian over the coming, for as long as it takes. The appeal is scheduled for the 27th of October, the next instalment in this very long saga of really what is the foremost press freedom case of our times. I'll be live tweeting the appeal if I'm granted access, along with other journalists. I heard concerning report today from a colleague in Europe that they have yet to decide whether to grant access to journalists to report on the video link. So we'll all be waiting to hear about that. But if we do, I can assure you, lots of us will be letting you know how things are going in detail. Thank you for joining us, and thanks to Politics in the Pub and Consortium News.